By the end of this lesson, you should be able to recognize the necessary elements of criminal liability, define the concept of Actus Reus, identify the types of Actus Reus, including conduct, state of affairs, consequences, including causation, and omissions. You should also be able to understand that Actus Reus generally must be voluntary, and use case law examples to illustrate and support the principles of Actus Reus above. Criminal liability is the legal responsibility for a criminal offence and makes a person subject to prosecution and punishment. If you are found criminally liable, it means you are guilty of committing a crime. To be criminally liable, the following three elements must be established. The Actus Reus of the criminal offence, which is the focus of this lesson. The mens rea of the criminal offence, and the absence of a valid defence. If any element is missing, there is no criminal liability. The term Actus Reus is Latin for guilty act. It refers to the unlawful thing that is done or not done. For example, for the crime of murder, the Actus Reus is killing a human being. There are four types of Actus Reus: conduct, consequence, state of affairs, omissions. For conduct crimes, the Actus Reus is a positive act that is inherently prohibited by law, regardless of the outcome. The focus is on what the defendant did, rather than the consequences. Examples include perjury, lying under oath, or driving under the influence, where the act itself is inherently unlawful. In conduct crimes, proving the defendant engaged in the prohibited act is sufficient for establishing Actus Reus. In the case of consequence crimes, the Actus Reus is not the conduct itself but the unlawful outcome it causes. In these cases, what the defendant does is not inherently illegal, it is merely what they cause. Examples include murder, where the consequence is death, and criminal damage, where the consequence is property destruction. When a crime is a consequence crime, causation must be proven. This means there must be an unbroken chain of causation between the defendant's conduct and the outcome. A defendant's conduct will be found to have caused the prohibited consequence if there is factual causation, there is legal causation, and if there is no intervening act that breaks the chain, also called novus actus interveniens. Factual causation is determined using the but for test. Would the consequence have occurred but for the defendant's actions? In other words, if the defendant had not done what he had done, would the outcome have been the same? If the answer is no, the defendant's conduct factually caused the consequence. If the answer is yes, there is no chain of causation, and the defendant is not criminally liable. The authority for this principle is the case of R.V. White. In this case, a son poisoned his mother's drink, but she died of a heart attack before the poison could take effect. The court held that the poison was not the factual cause of her death, as she would have died anyway. Therefore, factual causation was not established. The defendant's conduct will be found to be a legal cause of the consequence if its contribution to the outcome was more than minimal. The principle of de minimis states that the defendant's conduct must be more than a minimal or trivial cause, though it need not be the sole or primary cause. The authority for this principle is the case of Kimsey. The defendant, Kimsey, and his friend were engaged in a high-speed car chase. During the chase, Kimsey lost control of his car, which caused his friend's car to crash, leading to his friend's death. The exact details of the crash were unclear, and it was uncertain whether Kimsey's actions were the sole cause or one of multiple contributing factors. The court held that even if the defendant's driving was not the sole cause of the death, it was more than a de minimis cause, meaning that the defendant's driving had legally caused his friend's death. A novus actus interveniens is an intervening act that breaks the chain of causation between the defendant's act and the consequence. Three main types of events may constitute a novus actus interveniens: an act of a third party, the victim's own act, or a natural event. A third party's act will only break the chain of causation if it is not reasonably foreseeable. Something is reasonably foreseeable if it is a natural and probable consequence of the defendant's actions that an ordinary, reasonable person could anticipate. The case authority for this principle is the case of Paget. During a shootout with the police, the defendant used a human shield and the victim was shot by police. The chain was not broken because the police's actions were a foreseeable response to the defendant's conduct. Generally speaking, medical negligence will not break the chain of causation. The case authority for this principle is the case of R versus Smith. Here, a soldier stabbed another soldier who received poor medical treatment, e.g. being dropped twice, delayed treatment, and later died. Despite the inadequate medical treatment, the court concluded that the chain of causation was not broken because the medical negligence did not eclipse the defendant's initial act. An exception to this rule arises when the medical treatment is so grossly negligent that it can be considered an independent and overwhelming cause of death, as shown in the case of Jordan. In this case, the victim was stabbed and admitted to the hospital. While recovering, he was given an antibiotic despite medical notes indicating he was allergic to it. Additionally, the medical staff administered excessive amounts of fluids. This caused a severe reaction, leading to the victim's death. The court held that the treatment was palpably wrong and constituted a break in the chain of causation. A victim's own act will break the chain of causation only if their response to the defendant's conduct is so unreasonable or unforeseeable that it becomes an independent and voluntary act, severing the connection between the defendant's actions and the consequence. Two cases below illustrate this idea. In R.V. Roberts, the defendant made unwanted sexual advances towards the victim while driving. To escape, the victim jumped out of the moving car, sustaining injuries. The court held that the victim's actions were a foreseeable reaction to the defendant's conduct and did not break the chain of causation. The defendant was held liable for the injuries. The outcome of R.V. Williams and Davis, however, is different. Here, the defendants picked up a hitchhiker and allegedly attempted to rob him. The victim jumped out of the moving car and died. The court held that for the victim's act to break the chain of causation, it must be so daft or unreasonable that no reasonable person in the victim's position would have acted in that way. In this case, the victim's response was considered unreasonable because the threat posed by the defendants did not justify such a drastic action. As a result, the chain of causation was broken. Another way the victim can break the chain of causation is if they make a fully informed and voluntary act, as seen in the case of R.V. Kennedy. Here, the defendant, Kennedy, prepared a syringe of heroin and handed it to the victim, who voluntarily self-injected the drug. The victim subsequently died from an overdose. The court ruled that the victim's act of self-injecting the heroin was a free, voluntary, and informed decision, which broke the chain of causation. Kennedy could not be held liable for the victim's death because the victim acted independently, with full knowledge of the risks, and Kennedy's actions were not the direct cause of death. If the victim has a pre-existing condition, be it physical, mental, or religious, which exacerbates the harm, this will not break the chain. The thin skull rule holds that a defendant must take their victim as they find them, meaning they are fully liable for the consequences of their actions. The authority for this principle is the case of R.V. Blow. Here, the defendant stabbed the victim, who required a blood transfusion to survive. The victim, a Jehovah's Witness, refused the transfusion and died. The court held that the defendant must take their victim as they find them, the thin skull rule, meaning the victim's refusal of medical treatment did not break the chain of causation. The defendant was fully liable for the death. The victim generally has no duty to mitigate the harm caused by the defendant's act. Failure to do so does not break the chain. The authority for this principle is the case of Holland. Here, the victim refused to have an infected finger amputated after being injured by the defendant, leading to the victim's death from infection. The court held that the victim's refusal to mitigate the harm did not break the chain of causation. Similarly, even if a victim contributes to their death, the chain of causation remains intact if the defendant's original act is a significant and operating cause. The authority for this principle is the case of R.V. Deer. Here, the defendant attacked the victim with a knife. The victim, despite receiving medical treatment, later deliberately reopened the wounds, leading to his death. The court held that the chain of causation was not broken because the original injuries were a significant and operating cause of the victim's death. The court also reaffirmed that the defendant must take the victim as they find them, including any psychological vulnerabilities or unusual behaviours. A natural event will only break the chain of causation if it is not reasonably foreseeable. The authority for this principle is the case of Hart. Here the defendant assaulted the victim and left them unconscious on a beach below the high tide line. The victim drowned when the tide came in. The court held that the natural event, the tide, did not break the chain of causation because it was a foreseeable consequence of the defendant's actions. In criminal law, the general rule is that the Actus Reus must be voluntary. This means that the defendant's conduct must be a product of their conscious control. If the act is involuntary, such as actions resulting from a reflex or coercion, it cannot form the basis of criminal liability. The authority for this principle is the case of Hill v. Baxter. Here, the court provided examples where actions would not be voluntary, such as if a driver loses control of a car due to being stung by a swarm of bees, struck by a sudden illness, or hit by an object. Such scenarios demonstrate that the defendant's lack of conscious control over their actions negates criminal liability. However, there is one exception, and that is the Actus Reus of state of affairs crimes. The Actus Reus of state of affairs crimes occurs when the defendant is found in a prohibited situation or condition, regardless of whether their presence there was voluntary or intentional. It is the only exception to the rule that the Actus Reus must be voluntary. The authority for this principle is the case of Larsonneur. Mrs. Larsonneur was a French national who was required to leave England. In compliance with the order to leave the UK, she travelled to Ireland. However, Irish authorities did not permit her to remain in Ireland and deported her back to England against her will. Upon her arrival in England, she was charged with being an illegal alien under English law. Despite her involuntary presence in England, she was convicted. The court ruled that her lack of control over her circumstances was irrelevant, because the offence required only that she was in the prohibited situation. The general principle is that there is no duty to act. For example, if a passerby witnesses someone drowning, they are not legally obligated to intervene, unless there is a specific duty. Liability for omissions arises where the defendant is under a legal duty to act and fails to fulfil this duty. These duties are categorized into four primary situations: duty arising from a special relationship, duty arising from assumption of responsibility, duty arising from a contractual obligation, duty arising from the creation of a dangerous situation. A duty to act arises in familial relationships, specifically parent-child and spouse relationships. The rationale is that such relationships inherently involve a dependency or reliance on one party to provide for the other's basic needs or protection. The duty is to act reasonably in the circumstances. The authority for this principle is the case of R. v. Gibbons and Proctor. A father, Gibbons, and his partner, Proctor, failed to feed the father's child, resulting in her death from starvation. Both defendants were convicted of murder. The court held that the failure to provide food amounted to a breach of their duty. Consequently, their omission constituted the Actus Reus for murder. When someone voluntarily assumes care for another, they have a duty to act reasonably to prevent harm to that person. The idea is that once you take responsibility, others may rely on your actions, and failing to follow through could lead to serious consequences. The authority for this principle is the case of R. v. Stone and Dobinson. In this case, a couple, Stone and Dobinson, took in Stone's sister Fanny, who was mentally ill and anorexic. Despite recognising her deteriorating health and attempting minimal care, they failed to seek medical help, leading to her death. The court held that Stone and Dobinson had a duty of care because they voluntarily assumed responsibility for Fanny's well-being. Their failure to seek proper medical attention or provide adequate care amounted to a breach of duty, leading to her death. When a person enters into a contract that involves a duty of care, failing to perform the obligations under that contract can amount to the Actus Reus of an offence. The authority for this principle is the case of Pitwood. The defendant, Pitwood, was a railway crossing keeper employed under a contract to operate a level crossing gate. One day, Pitwood left the gate open and unattended while he went for lunch. A cart attempted to cross the tracks and was struck by an oncoming train, killing the cart driver. The court held that Pitwood's failure to close the gate, as required by his contract, was a breach of duty that caused the death of the cart driver. he was convicted of manslaughter. If a person contributes to, or causes, a harmful situation and they become aware of this, the law imposes a duty on them to take reasonable steps to prevent further harm. Failing to act in such cases can constitute the Actus Reus of a criminal offence. The authority for this principle is the case of Miller. Here the defendant accidentally started a fire by dropping a lit cigarette. Instead of extinguishing the fire or alerting anyone, he simply moved to another room and went back to sleep, causing the fire to spread and cause extensive damage to the property. The court held that Miller's initial act of starting the fire created a dangerous situation, imposing a duty on him to take reasonable steps to prevent harm. His failure to address the situation, or alert anyone, amounted to a breach of duty, and he was convicted of arson. To access the PowerPoints that I use in my videos, as well as other valuable resources such as case overviews, revision summaries, mock exams and others, visit my test store.